The Roman Republic, which existed from 509 to 27 BCE, is one of the most significant periods in not only Roman history, but also in world history. And it was marked by profound changes in Roman politics, Roman society, and importantly for our purposes, Roman law. This lesson then is going to explore the transition away from the monarchy to a republic which was governed by elected officials, laws, as well as a system of checks and balances. The legal system during the Roman Republic became increasingly more complex, where we see the mixture of written laws, edicts by magistrates, as well as the evolving interpretation of Roman jurists. Let's start to examine this system then, and I'm going to begin by looking at the political system, the political structure, and the idea of legal governance. So during the Roman Republic, the political structure was designed to balance power between various different elected officials and governmental bodies. This was to ensure that no single individual or group had a sense of unchecked power. This is a system that is crucial for the development of Roman law, but has many echoes in the modern world. When we think about the idea of checks and balances, that's essentially the process by which we think of the separation of powers, the idea of no one individual or no one single institution having unchecked powers. This therefore leads to the idea of checks and balances. So, magistrates were some of the most important of this new political and legal governance structure. Now, the magistrates were divided into a number of different groups, the highest of which were the consuls. They were elected annually, and 2 consuls held executive and military authority. They were responsible for administering justice, they were responsible for overseeing the Senate, as well as for leading the Roman army. Their power was significant, but the check that was imposed upon them was the fact that they had limited terms, a term of a single year, and by the requirement that they consult the Senate with other magistrates when it comes to making major political and legal decisions. Praetors were also very important magistrates, and they were responsible for administering justice and also overseeing the legal system. Their role was primarily focused on the judiciary and the overseeing of legal disputes. They had the authority to issue edicts. These were laws or legal guidelines. These edicts could modify or even expand upon the existing laws at the time, and address emerging legal needs over time. Now, over time, the praetors' power became more and more instrumental in developing the Roman legal tradition. This became important, especially when thinking about the creation of the jus honorarium, or the law of the magistrates, or sometimes abbreviated to the idea of equity, which we'll get to in future lessons. Aediles and tribunes were responsible for a number of different things. Aediles, for example, were responsible for public works and the maintenance of the city. And while their role was not directly related to law necessarily, they were involved in the implementation of certain regulations. Regulations including that of markets, trade, and public safety. So they played something of an executive role if we sort of think about the structures of governance that we see today in modern constitutional frameworks, especially modern constitutional frameworks that are influenced heavily by that of the Roman law. The tribunes of the plebs were officials elected by the plebeians. The plebeians, if you remember from the previous video, were the sort of common people, the sort of secondary class within Roman society. And they were elected by the plebeians to represent their interests. The tribunes had the power to propose laws and to also veto actions that they believed to be detrimental to that of the plebeian society, providing a legal check on the actions of other magistrates, including that of the consuls. This ensured that the legal actions would reflect both the aristocratic class, who we noted in the previous lesson were known as the patricians, and the plebeians, the common people. Now, probably the Roman Republic's most famous institution was the political body. This was the Senate, and it had significant influence over legal matters within the Roman Republic as well. Although it did not have direct legislative powers, the Senate could issue what were known as senatus consultia, i.e. Senate decrees. These were influential recommendations or guidelines that could essentially guide the actions of the magistrates. Now, over time, the Senate became an authoritative body, especially when we think about more political and, importantly, geopolitical matters, such as issues related to foreign policy, war, and finance. But it was often consulted on matters of legal reform as well as the interpretation of the law. The Roman Republic also had a number of assemblies that would represent different classes of society. The first of this was the Comitia Centuriata. This is an assembly that was organised by the centuries, the military units, and was primarily concerned with electing higher magistrates, like consuls and praetors, in terms of also other roles, including passing laws, approving major decisions such as declarations of war. The Comitia Tributa was the assembly that was organised by the tribes, the geographical or social groupings. These dealt with electing lower magistrates, including the aediles, for example, and passing certain types of laws, as well as serving in various different judicial functions. You also had the Concilium Plebis. This was the assembly of the plebeians and was an important part of the republican legal system as it had the power to enact laws. These laws became known as plebiscites. Notice the links and the connections between the language that we use here and the language that we start to use in the future. A plebiscite in sort of the modern contextualization is a bit like a referendum, a vote on a particular legal action. The enactment of laws, the enactment of plebiscites, applied to the plebeians, though over time these laws would be extended to all of the Romans. And so with this, at least at the earlier ventures of the Roman Republic, this was something that was very, very important to a very specific type of society, a very specific part of Roman society. But as time went on, the Concilium Plebis began to elect the tribunes of the plebs, who also played a significant role in legal reform. But more generally, the role of and the enactment of plebiscites would essentially extend to the whole of the Roman Empire, the Roman Republic, and so would play a very important role during this time. Now, as I mentioned in the end of the previous lesson, the Roman Republic saw the establishment and the shift away from customary principles, ideas about the law that were not written down, to the establishment of the first written laws, as well as the development of the first legal institutions, as well as, finally, the rise of legal scholarship and jurists. Arguably the most important of these key milestones that developed during this period was the creation of the 12 Tables. Now, the 12 Tables were the first formal written code of the Roman law, and they served as a foundational document for the development of the Roman legal system in the future. Prior to the existence of the 12 Tables, then, Roman law was based, as I've just mentioned, on unwritten customs and unwritten traditions, often which were subject to the arbitrary interpretation by the elite. During early Rome, it was the interpretation of the kings and the monarchs of the Roman system. And so the creation of the 12 Tables was a direct response to demands from the plebeians for a more transparent and accessible legal system. as they were often at the mercy of the aristocratic class, who would have a greater amount of control over the law. And so the 12 Tables covered a wide range of different legal topics, including things like property law, family law, a very important topic, that being of inheritance, debts, as well as the criminal law. The laws themselves were very simple, relatively speaking, and were designed to be easily understood by the average citizen. This is a basic principle of the rule of law, in fact, that we still adhere to, or at least try to adhere to this day. Although some judges in their high court rulings don't, for those of you who are studying English law especially. The 12 Tables would be displayed in public spaces, such as the Roman Forum, so that all citizens could know their rights and know their responsibilities. And this kind of gives rise to one of the basic equitable Roman maxims that ignorance of the law is no excuse. The 12 Tables were put in a public place, and they were publicly available for people to understand what is asked of them and what their rights are as a Roman citizen. It marked a shift specifically, though, for our understanding, away from customary law to a written law, and it ensured a more consistent and predictable legal outcome. They were not always comprehensive or detailed, however, and so it led to many further legal systems and interpretations over time in terms of the development. They were especially important for the plebeians, who had now a written legal standard in which they could challenge the aristocratic class. The jus civil, or the jus civil, refers to the body of law that applies to the Roman citizenry. It was initially based on unwritten customs and early Roman principles, but again, as it gradually evolved, it began to become more codified as the Roman state expanded. By the 3rd century BCE, the jus civil had become an organized system of rules governing personal status, properties, contract law, and other very important legal matters. Roman law during the Republic then saw the increasing sophistication in areas that I've just mentioned: procedural law, contract law, administrative law, laying the groundworks for later codifications. The jus gentium was something that we see when we look at the growth of the Roman power, and we start to see citizens begin to interact with the people of other nations, many of whom were not Roman citizens. The need then for a legal framework that governed relationships between Romans and non-Romans led to the law of nations, the jus gentium. It was a body of law that was based on the idea that certain principles of justice might be common to all human societies, regardless of their local customs or traditions. A sort of a pseudo-proto global justice-esque cosmopolitan principle of commonality across human societies. Now, the concept of the jus gentium is often considered to be one of the earliest forms of the idea of international law that we know of today, and it later influenced developments in diplomacy and the idea of trade. In terms of the idea of praetorian edicts and the jus honorarium, the praetors, as I mentioned already, were the judicial magistrates responsible for overseeing the legal system, especially when we see and look at the court system. Now, they had significant authority when it came to the shaping of legal practice through what became known as the Praetorian Edicts. These were issued annually, and they outlined the procedures and principles that would guide the administration of justice. The Praetorian Edicts were a form of executive law, and they supplemented the civil law. These were edicts that often provided remedies for a number of legal gaps in existing law, and also adapted the law to new socio-economic conditions. These edicts then played a key role in the development of Roman law, especially in areas such as the idea of equity and the concept of equity and the protection of individual rights. Now, equity is obviously a word that derives from the Latin aequitas, and for those of you who want to know about the sort of development of equity in English law, because equity and the idea of the trust and that kind of relationship between the law of equity and the common law is very, very much pronounced in the English legal system. Go and have a look at some of our lessons on the law of trusts, where I spent some time talking about the historical development of the court of equity, the court of chancery specifically. The jus honorarium is a term that refers to the body of law developed by praetors through their edicts. And so the jus honorarium allows for the flexibility in the application of law and addressed certain issues that might not have been sufficiently covered by the civil law itself, the jus civil. And so these groups of people have the power to create new legal actions for citizens to pursue their rights and remedies. And this practice then becomes the contributing factors that later develops or goes towards the development of the concept of equity, a branch of law concerned with the idea of justice and fairness. And then finally, I've mentioned that not only do we see a codification of laws, a development of legal and political institutions during the period of the Roman Republic, but we also see the development of an idea of jurisprudence and an idea of legal scholarship begin to develop as well. Particularly through jurists, who were typically wealthy, educated individuals who had the training and expertise in being able to interpret and clarify the law, do we see the development of legal scholarship. So the jurists would provide legal advice, responsa on often very complex legal issues, and their opinions were often cited by various courts or magistrates. Jurisprudence in the Republic would develop primarily through the work of public lawyers, and their contributions laid the intellectual foundation to the more systematic legal scholarship that would later characterize the Roman Empire. Prominent Roman jurists included, during the Republic at least, included individuals like Gaetius and Cicero, whose writings on law and justice would eventually lead to a lasting impact in Roman legal thought. Emperor Justinian, for example, in the 6th century CE, would incorporate a lot of the works that were developed by people like Gaetius and Cicero into the Corpus Juris Civilis, a sort of codification of the law that begins to exist as we look into the sort of the Roman Empire, the collapse of the Roman Empire, and the establishment of the Byzantine Empire later on in future videos.